Good afternoon, everyone, and welcome back for part two of our three-part series, Are You Ready for a Liability Claim? Before we get started, just the usual housekeeping items. Your phone has been muted, but if you have questions throughout the presentation, please feel free to use the chat box on the left-hand side of your screen. If you'd like to follow along with the slides as we work through them today, a copy of the presentation has been emailed to you. And if you are intending to apply for CPE credits, we'll be asking several questions throughout the presentation today. We'd like everyone to respond to those questions, but if you are applying for CPE credits, you do need to respond to those as a requirement. But before we get started, just a quick thank you to the folks at Wright Specialty Insurance for sponsoring this three-part series. Very much appreciate their involvement. Our presenters today are Jennifer Latner, Claims Counsel with Wright Specialty Insurance, and our friend who you all met before, Bob Bambino, Executive Vice President, also at Wright Specialty Insurance. Let's go ahead and get started.
Thank you very much, Bruce, and good afternoon, everyone. Thanks for having us back again today. This presentation today is going to be dealing with management liability claims, and by management liability claims, we're really talking about employment practices or employment liability claims. This is a little bit different or somewhat different from the discussion we had last week. Most of these cases are in the federal court system. They can be in state court as well, but the majority of them are in the federal court system, which is a little bit different. Employment liability claims or management liability claims, it's a very difficult exposure. These claims are somewhat kind of more personal in nature. They really deal with interpersonal relationships at work. There is a great reputation risk for the institution. If the claims get picked up by the media, they usually are shown in somewhat of a ugly light, I guess. They're very time-consuming in terms of the type of records that need to be produced. Jen will talk about, in this situation here, other than the discussion we had last week, there may be more than one or two people that will be asked to be deposed. This slide shows the leading loss drivers within our program here at Wright Specialty, and I would argue that this is probably very similar to other insurance companies and groups that are providing this coverage to private colleges throughout the United States. Employment discrimination claims, they run the gamut from gender-based discrimination to national origin. Usually with a discrimination claim, somebody will allege that they lost out on something, they did not get pay, promotion, their position was diminished somewhat, and that was due to their particular characteristic, which falls within a protected class. Wrongful termination claims are typically allegations of either a improper termination or a termination in violation of a person's of an institution's policies. Harassment claims are not just limited to gender; it can also include race, national origin, etc. Failure to accommodate pregnancy or disability-related conditions, and we'll talk about that in a little more detail. And reductions in force. Also known as layoffs, can occur system-wide throughout the institution, or it could be to one or two or three limited departments. But those claims also, that exposure also produces a good number of losses against our members. Bruce?
Yeah, let's go ahead and ask a question right off the bat here. Let me pull this up real quick. We want to know, has your college ever experienced discrimination, harassment, or wrongful termination claims? I'm hoping that everyone says no, but I don't believe that's going to be the case. Actually, it looks like most of you have. Okay, well, Bob, knowing that, let's go ahead and continue on.
Okay. Okay, so what we're going to cover, somewhat like last week, is but I don't think, probably won't spend as much time going over each of the steps in terms of defining it. We'll talk about the receipt of a summons and complaint, the defense counsel's obligation to put in an answer in response to that, The information that the insurance company investigators and defense counsel wants for this particular group of exposures is very different than what we talked about last week. The discovery demands and responses are somewhat different. In this case, the deposition profile is very different than last time. Post-deposition discovery demands, we'll go through that, and then the trial, in this case, will be in federal court, not necessarily in state court, and that is a whole different scenario. So, Jen, you pick up, why don't you kind of go through a little bit about the different type of liability exposures on the federal side and then on the state side.
Okay, sure. One of the most common federal law, and we'll start with federal laws, which applies to everyone, no matter where you are in the country. The most common claim that you'll usually see is under Title VII of the Civil Rights Act, and this covers discrimination based on several protected characteristics: race, gender, ethnicity, religion, nationality. Also includes harassment. So, a long time ago, and then over the course of the years since the 60s when the statute was enacted, discrimination was expanded to include harassment. The Pregnancy Discrimination Act was kind of a spin-off off of Title VII, and it made clear that gender discrimination includes pregnancy discrimination as well. Now, pregnancy discrimination could mean, employer, I told you that I was pregnant and you fired me, or you demoted me, or did something else bad to me. Or I told you I was pregnant and I needed a shorter work day or a weight restriction, and you told me no. So those are really the two kinds of claims that you'd get on pregnancy. Age Discrimination and Employment Act, also another very, very common statute for employees to bring claims under, especially as the workforce ages. And those are also usually pretty straightforward. And the protected class, it's interesting to note, in the Age Discrimination Act, it's still 40 and up. And which, if you're like me, I don't think that 40 is really that old, but if you're over 40, you can bring a claim under the Age Discrimination and Employment Act. And then there is the Americans with Disabilities Act, which protects people who have disabilities who are also, despite that disability, qualified to perform the job at issue with or without a reasonable accommodation. So those kinds of claims can fall into two basic categories, one of which would be I have a disability and when you found out you fired me or you didn't hire me. And the other would be I told you I had a disability and I could do the job if you made certain accommodations for me and you refused to make that accommodation. And then, and it's not down here as I omitted it, but with all of these, there also can be a retaliation claim, meaning I made a complaint to you, employer, that I felt I was being discriminated against under one of these statutes, and because of that complaint, you took an adverse action against me. So we will very often have an underlying discrimination claim, say somebody claims that they were sexually harassed. A court could find, well, no, this particular employee was not sexually harassed, but you did retaliate against them because after they complained, you fire them. So it's important to note that when you get these kinds of claims, you can't retaliate against the employee.
Jen, just quickly, what are some examples of retaliation besides firing?
It could be a demotion. Under the legal standards that courts look at, it has to be a tangible adverse employment action against the person, which would basically discourage people from bringing claims like that in the future. So we've had people bring claims saying either they were demoted or they were disciplined, something which really affects their employment. We've also had people say, I got dirty looks, people stopped talking to me. That's not going to cut it. And people will try that. They'll say, you made my work environment so hostile by doing this, but in the terms of retaliation, it has to be more than a dirty look or people not talking to them. And then over on the state side, the 50 states all have their own, most of them have their own anti-discrimination laws. So obviously we're not going to address them all today, but but to say, and it's also, important to consult your attorneys if you feel that a claim may be brewing as to what state laws protect, because some state laws are more broad than the federal laws, meaning, I know here in New York, for example, anyone of any age can bring an age discrimination claim. Some states have sexual orientation discrimination laws. So the state laws, again, can provide greater protection. State law claims, if they're brought on their own, can be brought in state courts, whereas federal claims are usually brought in federal courts. Many times an employee might bring a federal claim under a federal statute and then add in state law claims, and those will all be tried together in the federal courts.
So sexual orientation is not a protected class on the federal level?
It is not for private sector employers, public sector employers, a public college, for example. It would be covered under the 14th Amendment to the Constitution, which provides for equal protection. But under Title VII, at this time, there is no protection for against sexual orientation discrimination. Laws have been introduced. So far, they have not been passed.
Okay. So we are now entering the next presidential election cycle. Is discrimination based on a person's political views illegal?
For private sector employees, under the federal laws, there is nothing that prohibits an employer from discriminating based on somebody's political party, political activities, unless if the political activities are, someone might say, well, you're rallying, you're doing something during work, it's reflecting badly on us. At this point in time, there is no law that protects against that, making an employment decision based on that activity. That said, there are some state laws which may provide protection for people claiming that they were either discriminated against based on their political views, some sort of legitimate out-of-work activity that the employee was engaged in that the employer took issue with. But under the federal laws, at this point, there is no protection for an employee of a private sector employer from discrimination based on political views.
Okay, thank you.
Okay, so we're on the slide that discusses defenses. Now, the reason, we don't want to get too legalese here, if that's a word, but the reason that it's important for you all to know what defenses to these kinds of claims are is because before a claim arises and after a suit comes in, there are certain things that assigned defense counsel or your defense attorneys are going to be looking for that will help them to defend the claim. So the most important thing that they're going to be looking for is, all right, employee Jane Doe says she was terminated because she's a woman. Why did you terminate her? Was there a legitimate reason? Well, yeah, she was falling asleep at her desk every day. We didn't want an employee sleeping on the job. Was it documented? People are going to be looking to see, all right, well, you're saying this is the reason. Can you prove it? Do you have a memo that was written to her? That kind of thing that backs up what you're saying the legitimate reason is. In terms of harassment claims, one of the best defenses that we have is that we had a very well-worded, strong, and well-communicated complaint and investigation policy. So employees knew that if they had a complaint to make, they knew who they could go to and what the procedure would be. Our investigation was done promptly. It was done fairly, because if the employee didn't take advantage of those policies and they went straight to filing a lawsuit, they can end up getting their claim thrown out. So it's important to have these policies, and it's important to use them and make sure that people know about them. For an ADA claim, one of the strongest defenses is going to be that, okay, well, we knew that John was disabled, and we knew what kind of accommodation would help him, and we offered it. But it wasn't the specific accommodation that he wanted. Well, under the law, you don't have to give an employee exactly the accommodation that they're looking for. It just has to be reasonable, and it has to enable them to do the job. An accommodation could be allowing them to have a weight restricting. So say you have a custodial employee who says, I can't lift over 80 pounds, let them lift only 60 pounds. Sometimes a reasonable accommodation could take the form of a reasonable leave of absence. There are a whole bunch of things that could qualify, and the employer has the responsibility to engage in what the courts call an interactive dialogue with an employee who either asks for an accommodation for disability, or without even coming out and asking for it, if the employer knows that they have a disability and they kind of come to you and say, look, I have this disability and it's affecting my work, kind of have the obligation to engage in this dialogue with them. Courts are looking for that.
So changing someone's workstation, maybe modifying their hours a little bit.
Exactly. And, especially when you're talking about people have these sort of ergonomic sort of injuries now, which are common, carpal tunnel, provide them with certain equipment that will make it easier for them to use the computer. We get a lot of, in some of our educational institutions, people claiming mold. They're exposed to mold in the classroom, and it's, they have mold sickness, which some people believe in and some people don't. So maybe you need to change their room, maybe you don't. But and also in this, it is also the employee's responsibility to bring in medical documentation. So a note from a doctor saying, Teacher Jane gets migraines. Teacher Jane needs to be in a room with an air conditioner, and so you don't just have to take their word for it. They need to provide medical documentation. And then talking about reductions in force, well, you could have a group of employees who say, you know what, there were all these layoffs done, and it only affected people who were 50 and over. If that's the case, why was it? What exactly were the position eliminations based on? How did the institution select the positions? It's got to be based on some kind of neutral, non-protected, non-discriminatory criteria. It could be seniority, could be department, could be what's more essential, to what we feel is our core curriculum. Do we really need this art class? Is a certain math class more important? So those are certain things that you all can do on your end when employment claims are brewing or when a complaint comes in. Start to kind of get these things together so when the attorneys ask for it, you don't have to kind of first go hunting for it. You're really looking for, what they call a paper trail. You really want to be able to see in documents the kinds of evidence that will be presented in court to defend the claim.
What's one or one of the leading causes, or in terms of the clients, where would you say you see them dropping the ball? Is it handling complaints? Is it not having the policies? Is it not communicating the policies?
A lot of times it is not documenting performance problems.
Interesting.
Especially in the education realm, we have found that educators are reluctant to put on paper anything negative about other educators. So, for example, we might get a race discrimination claim. An employee might say, you didn't give me tenure or you terminated me because I'm African American, and the employer says, no, we terminated you because you were an ineffective teacher. Well, let's get out those observations and evaluations and see. It doesn't say anything bad. So it is the plaintiff's burden to show that they were discriminated against based on race, but it then also falls to the employer defendant to show a legitimate reason why the person was terminated. So if you're saying it was for poor performance, it really helps if you have those observations, those evaluations, or memos which show that there was, in fact, a performance problem and therefore it had nothing to do with the person's race.
And I would also offer that that phenomenon is not just limited to educational institutions.
Yes, I agree. That's who we deal with,
Right.
so that, in my experience, and it's not necessarily a negative thing in the real world,
Right.
in the court world, it's negative.
Right. I think it's indigenous to some insurance consulting firms, too.
Could be.
Okay.
Okay, religious discrimination falls under Title VII, and interesting for this group is that not only might you have a claim by somebody saying I was terminated or not hired because of my religion, but if the statute specifically says that if an institution is religious in character, in other words, purpose and character of the institution is primarily religious, then an employment preference is allowed for members of that institution's own religion. There is a ministerial exception as well, which applies only to employees who perform essentially religious functions. And in addition to that, courts have found, this isn't in the law, but courts have found that clergy members can normally not bring claims under most federal employment laws. The reason being, and this is included in some EEOC guidance, that courts have generally found that for federal law to interfere in the employment of clergy violates the First Amendment right to free exercise of religion and constitutes government entanglement in religion, which is prohibited under the First Amendment. Some courts have allowed harassment claims, finding that doesn't go so far as to interfere in the employment decisions of clergy, but if a clergyman or a woman claim that they were being harassed, that claim may be allowed to go forward.
In terms of the second bullet point, about how this applies, the ministerial exception applies to employees who perform essentially religious functions. So we would get that, I would think, somebody who's a religious counselor, somebody who's teaching, let's say, theology classes. And on the other hand, I would think about, let's say, an athletic director maybe being exempted, maybe a person who works in buildings and grounds. But what about somebody, and I hate to ask you a hard question where you're not, I didn't tell you I was going to ask it, but what about somebody who, let's say, is a social science professor who teaches a couple of classes that are theological, or maybe an athletic director who does some religious counseling also? Does that push them in that protected area, or is it really case by case?
I think it's going to be case by case, and the court in that case is going to really look probably to see percentage-wise what amount of the person's duties falls under a religious category as opposed to a secular category.
Okay.
Okay, pregnancy discrimination is another sort of big claim that we are seeing, and in fact there was just a week and a half to 2 weeks ago a big Supreme Court decision. It was the case of Young versus UPS, and in that case a woman became pregnant. She was a driver for UPS, and she asked for the reasonable accommodation of a weight restriction. She brought in a note from her doctor saying she was not allowed to lift packages over a certain weight. The employer, UPS, said no. She sued. She lost at 2 levels, and the Supreme Court sent it back to the Court of Appeals. And what the court said was that UPS would allow weight restriction accommodations to be made for people with on-the-job injuries, for drivers who lost their certifications, even though there were other employees that they did not allow those accommodations for. Because they allowed it for some non-pregnant employees, they had to allow it for pregnant employees. So the basic thought to come out of this case, which sort of expands on what it was before, is that accommodations for pregnant employees who ask for accommodations have to be made in the same way that they're made to any non-pregnant employees with similar work restrictions. If they don't, if the employer does not do this, they're going to have to show a legitimate non-discriminatory reason for denying the request for the accommodation. And they also have to show that that policy does not impose a significant burden on pregnant workers. Now, Those last 2 points have not been tested yet. This case just came out, so it'll be interesting to see what courts do with that. But at this point in time, to be safe from these claims, employers should accommodate pregnant workers in the same way that other injured workers are accommodated, whether they do that for all employees or just a small group. You have to, and it sort of gives pregnant employees what people have been calling a most favored nation status. It sort of signals them out from maybe special treatment, but that's what the court is saying right now, so that's what employers need to do.
Go ahead and ask another question here. Let me pull this second one up for you as well. Okay, who handles employment harassment and discrimination complaints on your campus? Maybe it's the business office, human resources, maybe you hire an attorney as you need one, maybe you have your own risk management department or on-staff legal, or maybe no one is assigned. Like the vast majority of you handle it out of human resources. Bob, I would think that would be fairly typical, and that's as I would expect. You too?
Yeah, I think that makes sense. I also think, maybe involving your attorney, if hopefully everybody who's on the call here is not getting 2 or 3 of these claims a month. And when you get them, if you don't get them frequently or you've never gotten them before, getting one is it's a pretty traumatic experience. So maybe, yes, HR definitely, I think that's pretty much the norm. But I also think maybe a call to counsel is not the worst thing. Also, you want to get that over to your insurance broker as quickly as you can. The insurance broker is going to need to forward that over to the carrier. Now, the HR part of this is fine, and I say this respectfully. You'd want to make sure that the people that are in the HR department know what to do with the information, other than certainly referring it to the insurance company. If there is a need for an investigation, a follow-up, one of the dialogues that Jen talked about, we hope that the people in the HR department are generalists or have experience and know what they have to do in that particular situation and what your policies and procedures are. That's why sometimes I think a call to counsel, the attorney might say, okay, right now, according to our policy, in this particular area, you need to think about putting together an interview and an investigation. And if the HR person, so Jen, if the HR people, let's say it's a relatively small institution, if the HR people are, let's say, friends with, they know, they're colleagues with, both of the parties, let's say you have a department chair and then you have a professor, what does the HR person do? Do they just go ahead and do the investigation? Do they reach out to someone else? Do they? Because I guess you don't want to seem like, hey, no matter what you decide, the other person's your friend, the buddy. There could be an allegation of whatever.
If there's going to be if you're anticipating that there's going to be clear bias, like let's say one is your good friend or a relative, a sister-in-law's uncle or something like that, no, the HR person shouldn't do it. We see a lot. Sometimes kinds of investigations are contracted out. There are not necessarily law firms. Sometimes they're law firms. Sometimes they are companies whose specific job it is to perform these kinds of workplace investigations. So that's an added expense, obviously, to have an outside attorney or consultant perform these investigations, but it's also the best way to protect against anybody claiming that this was a biased investigation. It's also good for any policy to have a means of appeal. So if somebody is attacking the investigation and saying, well, our HR person was biased, there's another level. There's someone else you can go to. Is it the dean? Is it any other college official that could examine this and look at what was done? That's a great way to protect yourself against the claim that the investigation was biased.
And the investigation, could it be done by one person? Does it have to be like a committee? Does it need to be 3 or 4 people?
It can be one person. It can be one person. Sometimes that one person who takes an interview might want to have somebody with them as a witness.
Okay.
but the actual person who is doing the investigation or responsible for the investigation, it can just be one person. Having a witness basically just precludes the person that you interview from saying, I never said that. You know, if there's a witness there, the witness can say, you know what, I was there. Is it, an HR clerk or, somebody else, who's not involved in the situation? They can testify, I was there. You did say that you never saw Jane get harassed. So now you're saying that, you did? That doesn't make sense.
Okay. All right. So what we'll do, I think, for the remainder of this discussion is to really go through the different stages in the litigation process and apply them to this particular exposure area. Once again, I just want to remind everyone that all insurance policies, regardless of who the carrier is going to have some, it's called duties after an accident or loss. And usually, I think it's safe to say that there's two things you need to do. When you're aware of a claim situation, you have a responsibility to promptly notify the carrier. This certainly can be done through your insurance agent. I would imagine that if someone comes in and tells you that they feel that they're a victim of harassment, discrimination, if they were wrongfully terminated, if they've been working in a hostile work environment, if they tell you that even without an attorney's letter or the service of a summons and complaint, that's probably something that you definitely want to speak to your insurance broker about and letting them give you some guidance as to whether or not it needs to be reported to your insurance carrier. I'm thinking that most brokers would probably go ahead and do that. And if you are served with the summons and complaint, as we talked about last time, that also has to get to the broker as quickly as possible, and it needs to go to the carrier. But in addition to that, it's not a bad idea to note how the summons and complaint was served. Who was it served on? Did you get it in the mail? Was it left with somebody? Was it served with somebody in person? Because I think the service process server is probably going to be making notes also.
Yep.
Okay.
And I know we do have, not everybody uses it, but I know that there is a form that policyholders have from the insurance company that has, a space for you to fill out all that information when you send us, or whatever insurance company, when you send in a summons and complaint that says the time, how it was served,
Right.
Location, that information.
Now, is the service of a federal summons different?
It's basically the same. Each state has their own civil procedure rules for how service may be effected. Federal law also has its own rules. One thing that may be a little different in federal court, sometimes a plaintiff is allowed to serve a complaint without a summons and serve what's called a waiver of service, which we like for policyholders to send to us without filling it out. But basically what that does is say, I don't want to go, the plaintiff doesn't want to spend the money on a process server to serve the summons, so they will mail you the complaint or deliver it in some cheaper fashion. The person who receives it signs off on it. That then doubles your time to respond to the complaint. So instead of getting, say, 20 or 30 days, you will get 60 days. And the federal rules say if you get that form, you better sign it, or else if you make the person go through the cost of actually serving you with process, you can be assessed those fees.
Okay.
So that is one thing that could be a little bit different, but we like it because it gives us more time to, investigate and to, figure out what's going to go into the answer.
Okay. Now, talk about the concept of a litigation hold.
A litigation hold, and some of you, if you have gotten these claims before, may have seen letters from your defense attorneys. A litigation hold simply means that you have now received a complaint from John Doe alleging that he was wrongfully terminated. You now have to make sure that you do not destroy or otherwise delete or get rid of any documentation or information that could in any way be related to this case. So that includes paper files, electronic files, emails, faxes, everything. And if you do not preserve all of those records, the plaintiff asks for something and you then have to say, we don't have it, it was destroyed, The jury, if it goes to trial, can be given what's called a spoliation charge, which means that they are allowed to consider that adversely against the defendant. You don't want to end up with a spoliation charge, especially when you weren't trying to hide anything. It's just that something accidentally got thrown out or deleted. So once you have notice, and some plaintiffs' attorneys will, before they even file suit, send a letter that says, "Dear employer, your employee has come to us, she's hired us as an attorney, she's going to file a claim against you. You now have a duty to preserve all records regarding our client." When you get that letter, anyone in the institution who may have any kinds of records on the employee needs to be told that there is now a litigation hold in place. Do not delete any emails, do not throw anything out, you have to maintain everything.
And that also extends to cell phones, tablets?
Well, to the extent that they are employer-owned,
yes,
then yes.
Okay.
If there's anything that's if there's an email on a cell phone or a tablet that for some reason is not on a desktop or a laptop computer that is actually on the site of the employer, then yes, that needs to be maintained as well. Okay, so the stages in the litigation process, we're up to insurance company and defense counsel investigation. This is very similar to what you may have heard in the session that you attended last week. But basically, your role, and in this kind of a case, in an employment case, you will probably be coordinating with the Human Resources Department to provide records. Actual evidence is not going to be as prevalent in these kinds of cases, but it is mostly going to be employment records, any emails related to the person's employment, personnel files, policies, employee manuals. Those are going to be the kinds of things that the plaintiff is looking for in discovery, and so when we're doing the initial investigation, we want to know what they're going to find and what we're going to be turning over to them. And also in the course of that investigation, we will be interviewing the key players in the situation, which could be other employees, which could be coworkers of the person bringing the claim, will most likely include HR staff, because when you're talking about an employment decision, HR is almost always very involved. The employee supervisor, who may have been the one to make the decision, and any witnesses, which, especially in a harassment case, there may be other employees or people who may have witnessed something going on. So that's going to be basically what we're looking for when we start to conduct the initial investigation, be it the insurance company or defense counsel.
Now, some of these records could hold confidential information.
Especially when you're giving it to the defense attorney and even the insurance company who's really acting as your agent, that confidential information can be provided to the insurance company and to defense counsel. We can talk in a little bit about what will then happen with that confidential information once the discovery process begins. But for the sake of the initial investigation, the defense counsel and the insurance company need to see everything. And it usually is more the defense counsel who will be looking at this kind of stuff. And there is, privilege there, so they have to hold everything confidential.
Okay, so in the discovery and demands and responses, this is the stage, if I understand it correctly, where the plaintiff's attorney is now asking for specific information, documentation, records, things like that. Now, does a court order that? Like, does the judge say you must do this, or is it simply something between the two parties?
It can actually go either way. In federal court, the one thing that is mandatory in the federal rules is something called initial disclosures. So after the complaint is served and the answer is filed, and there's something called an initial discovery conference, which will take place between the attorneys in court. Initial disclosures are very basic information which the parties will have to exchange. which is for the defense side, it will usually be, limited to the insurance policy, which does have to be disclosed, and some other very, very basic information. Then the court will set a discovery schedule and basically say that, okay, discovery needs to take place by this date, depositions need to take place by this date, everything needs to be done within the next 6 months. So the discovery demands that the plaintiff will serve will usually be interrogatories, which are written questions, and document requests. They don't have to do it, but any plaintiff's attorney who doesn't do it is not a very good attorney, and I've never seen a case where they haven't done it. So they will be looking for, especially in documents, they will be looking for employment records. They may be looking for employment information about other employees. The defense attorneys can object to demands, and they can also provide information which has been redacted, meaning confidential information such as employee names or social security numbers. Anything that's confidential will be blacked out. So the other side will not see that. Anything that's related to the plaintiff, obviously, you're giving it to the plaintiff, you're giving it to the employee who has brought the suit against you, so you can give them everything that you're asking for.
Okay, so let's say you have a situation where, most documents are obviously electronically stored. Let's say there was a problem with a hard drive, a problem with a server, and you get a phone call that says, listen, I can't believe you asked for these documents. This was prior to, whatever date in 2014 we had a problem with the server. We lost documents. We had them, but we don't have them now. Do they have to recreate them?
You may have to recreate them. You may need to, the insurance company, and going through this right now in a case where a teacher is claiming wrongful termination. The hard drives were swapped out, and we've had to pay a consultant to basically try to pull huge amounts of data off of an old hard drive. So, yes, courts have basically been telling us, you need to do whatever it is that you have to do, and we don't care how much it costs, to recreate that information. If it's starting from scratch and physically, saying, well, we lost that memo, but we know we wrote her a memo, so I'm going to write it again, that's not really going to fly. If you don't have it, you don't have it. But something electronic that's been lost, whatever can be done to try and bring that information back is going to have to be done.
All right. And what about an employee who, say, left the college's employee and they took records with them?
That information needs to come back.
Okay.
Somebody's going to have to talk to that employee and have them bring it in. They will most likely be subpoenaed to testify as well if they were somebody who had that information. But again, when a litigation hold is sent out, if there's anybody that you think has left the employer who may have relevant information, a letter needs to be sent to them telling them that they need to maintain this information.
So let's say that plaintiff wants all annual evaluations of this particular employee going back 5 years, and let's say that in year 3 and 4, for whatever reasons, you didn't do an evaluation. You don't have to. You don't have to create anything.
No.
You could just simply say we didn't do it. We
No.
don't have. Okay.
You say you didn't do it. Yeah. If you don't have it and it never existed, you can't produce it. That's that.
Okay.
Okay, depositions. Depositions work a little different in these kinds of claims as well. For starters, there are going to be a lot more of them. Plaintiffs will normally seek to depose the employee's supervisor, the person who made the employment decision that's at issue, coworkers, people who may have experienced similar kinds of treatment, HR employees will normally be deposed. So it could be, you could have 6 or 7 people from the institution who end up getting notices for depositions from a plaintiff in an employment discrimination case. That deposition prep that you will be, or a witness will be meeting with defense counsel beforehand is probably going to take several hours. This will be a very time-consuming process. These cases tend to get complex. After the deposition actually takes place, the witness will be sent a copy of the deposition transcript and given an opportunity to make corrections. And then that gets sent back to the defense attorney, who will then give it to the plaintiff, and, they'll basically be saying, look, he said, he never saw this at the deposition, but then he remembered he actually saw something like that, so we're correcting it. Post-discovery demands also may come out of deposition. So if a witness testifies about a certain document that was not turned over before the deposition, the other side is going to ask for that. So anything that they feel they've now been made aware of through deposition, they're now going to come back and ask for. So an institution shouldn't be surprised to get a further request from the defense attorney saying, all right, I know I asked you for A through Z, now we need, 1 through 10.
Okay. And you had mentioned the people most likely to be deposed in this example would be HR people, I guess the plaintiff's supervisor perhaps, or manager, department head, possibly a dean, and then coworkers who may or may not have witnessed this?
Yes.
Okay. What happens if the coworkers say, look, I don't want to get involved here. I'm not a manager, I'm not a dean, I'm not a department head,
They really don't have a choice.
Okay.
And if the employer can't make them appear, which really, because they're an employee of the named defendant, they become a party themselves, the plaintiff can always serve them with a subpoena, and if they don't respond to the subpoena, then they can be made to pay fees. So, unfortunately,
Right.
When it comes to this kind of stuff, there's not much of a choice.
All right. So in terms, when we think about the questions that are asked, let's say you have a harassment case where, let's say it's a gender-based harassment case where a person is claiming that they worked in a hostile work environment. Maybe they're the first female maintainer on a staff that was traditionally men forever. And this person's claiming that, I'm getting email from people leaving pornography on my desk, they're sticking things in my locker. In a situation like that, if you were, let's say, that plaintiff's boss, you were the foreman, superintendent, or whatever, what type of questions would you expect to get on the plaintiff's side?
They're going to be asked, first and foremost, probably, did she ever come to you and complain? Because most likely she's going to be saying, this was all going on, and I complained to my supervisor, and nothing was done. So they're going to want to know, did you get a complaint from this person? What, if anything, did you do? Who did you talk to? Also, did you see anything? Did anybody ever show you that this stuff was going on? What did you do about it? Who did you talk to about it? If the person claiming harassment is also claiming that some kind of adverse employment action was taken against her because of a complaint that she made, the supervisor would also be questioned about what action they took against her and why. So there's kind of two things. Okay, you were met with a complaint, what did you do? And it may be as easy as, I forwarded it up to HR, and that it ends. A lot of times the supervisor will just say, okay, I'm telling Human Resources is going to deal with it, and that may be the end of that. And then they also may be asked, okay, well, you changed this person's shift. You put her on the night shift instead of the day shift. Why did you do that? Did you have any other employees whose shift you changed? Or you only changed male? You didn't change any male shifts. Why did you just do it for this woman and not for men? So those are the kind of things that they'll be asked.
And in let's say a wrongful termination claim where, let's say you have a professor, the university or the college has a progressive discipline approach. They have a policy in terms of disciplining someone. Immediate termination is limited to a few very restricted categories, like somebody committing a crime, assaulting another person, or whatever it might be. If someone says, look, I was terminated very quickly, I never had a chance I wasn't offered any counseling, I wasn't offered a progressive discipline approach, I wasn't given a plan, they just terminated me right away, what who would probably be asked to be deposed, and what type of questions would they get?
It would be the person who was responsible for any kind of discipline of that employee. So be that the supervisor or human resources, those would be the people who would be deposed. The questions that they would get would be, what is your policy? Do you have a progressive discipline policy? What is it? Have you had any other people who you terminated for this specific offense? If not, why didn't you terminate them and you terminated this person?
Right. Okay.
Okay, trial. Trial in these kinds of cases and employment practices cases can last several days to several weeks. The longest I've been involved in is 6 weeks, and that was because plaintiff's attorney was allowed to get away with things that they shouldn't have been allowed to get away with, so that's kind of a worst-case scenario. It could be as few as 4 days. They're usually not shorter than that. And they are handled in federal court. They're sort of very structured. The federal judges usually keep a very tight rein on things. They try as best as they can to let witnesses know when they will be appearing. Schedules have to kind of stay flexible. Defense attorneys will let all of the witnesses on the witness list know that the trial is going on, starting at a set period, and here's when they can expect to be called. They may end up sitting around the courthouse for hours. They may end up wasting a whole day sitting at the courthouse. It's the nature of the beast, and unfortunately, that's what happens. They will be usually questioned by both the defense attorney, who will be friendly, and the plaintiff's attorney, who will most likely not be friendly. They will be questioned on cross-examination, which can get a little hostile. And again, testimony could last for a witness, depending on who the witness is, an hour to an entire day of testimony, to a day and a half of testimony.
Well, in federal cases, is it so? In other words, your feeling is that it's more structured, so it's less. You're going to be given some advance notice, and like, for example, you may be called on the third day of trial, which could be Friday. So then you would anticipate as an attorney that that person would put the day aside and make themselves available to come in.
Correct.
Okay.
Correct.
Last week we talked a little bit about like what you guys like to see in a witness. I think Paula mentioned she likes people who pretty much say yes, no, I don't know, and I don't recall.
That's actually very, very accurate. You don't want a witness you don't want a witness to answer more than the question that was asked of them, especially when it's the plaintiff's attorney asking the question.
Right.
Don't give them any more than they asked for.
Okay.
So yes and no is very, very helpful. I don't recall. If you don't recall, you don't recall.
Right.
Not that I can recall. I don't like as much. That sounds a little more hesitant, but I don't recall. I don't remember. These things can take years to reach trial, so it is completely possible that you really don't remember. On, Tuesday, January 27th, 6 years ago, what was said to the woman sitting at the cubicle next to you?
Okay.
So it happens.
And obviously, we don't have it down here as a step, but if a verdict comes in that we feel is incorrect, there's an opportunity for an appeal?
Yes, there's an opportunity for appeal, and usually that is something that the employer doesn't really have to be as much involved in. It's legal arguments made by the attorneys. It can result in a new trial, so it's not impossible that the whole process could start over again. Well, you don't go back through discovery, but there could be another trial. It's very rare that the matter wouldn't be settled if that did happen. Nobody wants to go through two trials. So, yes, but there is a post-trial procedure if the verdict is adverse.
Okay. And if you could remember, Jen, for these type of cases, typical verdicts where a jury goes in a room and tries to decide a dollar amount?
We've been really surprised. We've had anywhere from $90,000 for a sexual orientation discrimination claim to $1 million for a school district administrator who claimed race discrimination.
Okay.
So they really fall along the gamut. There's usually a mechanism to, appeal to the court and say, these damages are very specific. You have back pay, you have front pay, there may be emotional damage if the employee says that, they were emotionally damaged or they sought treatment from a psychiatrist or a doctor. So they're a little harder to qualify than, say, a broken knee or something that's physical that, by this time there's sort of a dollar value given to specific injuries. These kinds of cases really run the gamut.
Okay, here's our next question. This question really relates to the fact that we have institutions full of folks that don't have law degrees. So how often are you doing training for your staff, especially anti-harassment and discrimination training? Annually, regularly, maybe something other than annually? Maybe you're only doing it for new employees. Maybe you never do it, or maybe you're not sure. Let us know. While we're watching the results come in, Bob, what is your recommendation? How often should we be doing harassment training?
All right, I'll give you my answer, and Jen will give you hers. I think anybody who's coming on for the first time has to go through some type of training in terms of what the college expects, what is prohibited, what is illegal, what's not allowed, and most importantly, what you can do if you feel that you are a victim of harassment or discrimination, or you feel that your race or another protected category was a reason for you to be terminated improperly. I also caution people to remember second shift folks. A lot of this training is done by HR or set up by HR. So if you have a second or third shift, you want to get those people in as well. Also want to include any seasonal people. If you have folks coming in, after the spring semester ends and they're doing landscaping work, maybe construction, they might be kids that are hired for other reasons. You want to make sure that they're given the same type of training as well. I like annually. I don't know how often that's done. I think that you could do annual training where you're primarily reminding people if something has changed. For example, if there's a change in the law, you certainly have to communicate that, but I think annually is a refresher, reminding people. And then the last thing I'll say before I ask Jen is, you got to kind of look at what happened. I mean, if you've had a couple of claims where there was some issues based on, let's say, some pregnancy discrimination, or there were people who were asking for reasonable accommodations and they felt they were not getting them, that's something you might want to emphasize. You don't want to give up the confidential information, but if you feel that, you might have been vulnerable in that area, then that's something you want to talk about. But I think to emphasize it every year, certainly cover any new changes in the law, new regulations that come down, good idea.
Yeah, I would agree with that, and also just add that you also want to make sure to get employees to sign off that they have received the policies and that they've attended training, be it whether it's somebody who then later makes a claim, they can't say that they weren't aware of this stuff, and somebody who is accused of violating any kind of harassment policies, at least the employer can say, well, we did send them to training, so we kind of did our part. But I do think that, I agree, certainly all new hires. If annually is too much, then definitely every other year, just so this stuff stays fresh in people's minds and they don't, forget that certain behaviors are not cool.
And I would also say that you might have departments where you feel that you might have an issue or a problem for whatever reason. First female person, maybe it's the first time you have somebody who's wearing maybe religious attire. It might be a department run by a very capable superintendent, supervisor, department chair who has had a problem along the way and it doesn't really rise to termination. So maybe when that group gets together for technical training, you might want to somehow include this along the way. All right.
What about before we move on, what about the case of an adjunct, where we might bring an adjunct professor in for one class? If we're doing training every 2 or 3 years or 18 months or whatever, we may have long passed their time with us. What do we do about that?
Yeah, that's an interesting question. I think giving them the institution's policies and procedures, I think you got to do that. Telling them that there's an expectation that they'll be looked at. And, in the typical, like HR hire, what do you talk about? Wage, possible benefits or no benefits, how you get into the building, do you have a pass, where can you park, what the chair expects of you. And you might also include, oh, by the way, if you go on the website and you get into the section where the employee handbook is, there are some things we need to talk about. This is how you call in sick. If you have time, this is how you take time. And also, there are issues in there about how to report a workplace-related accident on the workers' comp. And if you feel that there's a problem in terms of harassment, discrimination, or whatever it might be, this is the reporting procedure in your department. You can go to your chair, and you can also go to this person, and you can also go to another person.
I would agree with that. You want to just basically give that person, you're going to be giving them, I'm sure, lots and lots of forms and references and things to look at, even if they're just going to be there for a semester. So this just needs to be included. You certainly don't have to have them come back the following year and attend, the training that you're doing then if they're not going to come back. If they're there when the training is going on, then, I think they should attend. But other than that, giving them the policies is probably the best way to go.
Bob, the examples that you've given have primarily talked about how to respond to harassment or what to do when you feel harassed, but I'm assuming that you're also meaning here how not to harass and how not to discriminate. I think sometimes we need training in that regards as well.
Yes, and that's called sensitivity training. And you're right about that. You would think that, I think for most of us, we kind of understand, where the line is. And, we also recognize that there are some people that are very sensitive. There are other people that are relatively thick-skinned. You would think that you don't necessarily need to do that. I think most of the requests that we've gotten for sensitivity training is usually in response to a situation that has arisen, whether it led to litigation or not. I think to maybe kind of frame that in terms of, look, we work in a diversified working environment. What was okay 20, 30 years ago, or okay for maybe our parents' generation, or maybe okay when we were younger, really does not fly in this particular environment, so we need to be sensitive to the people around us and what their respective beliefs and what they're like as different individuals. I get that. There are many of our clients that do this. They usually include it in, let's say, new employee orientation, or maybe for just some training overall. Webinars like this that can be done and recorded and put on the website are great ideas. If you feel that there is a developing problem, yes, then we would recommend sensitivity training. Bruce, have you come across, without giving up any names or anything like that, have any of your clients asked about that?
I have heard conversations along those lines, yes, just because I think sometimes our folks feel like not everyone really does understand what it means to not harass someone. They're just ribbing and having a good time, or maybe sharing their opinion, and the other person is like, this person needs to stop harassing me. I have heard those conversations, yes.
And I have to tell you that I've been involved in that as a consultant, but I've also been involved in that as a boss. And I will tell you, it's much easier as a consultant than it is as the person that has to make the decision. But I would agree with you. There are people who don't understand where the line is. And some people, they get on a roll and they really don't know how to stop. Jen, if one incident of, let's say, harassment, is that enough?
It depends what it is. If it's an assault, then yes, it's enough.
Right.
If it's a remark, then one time is not enough. I mean, the buzz language from the courts is that it has to be severe and pervasive,
Okay.
which means it has to be bad and it has to occur a lot. The less serious it is, but the more that it occurs is when there's a problem, and that's usually the cases that we get, where it's not, a physical touching, but it's some kind of remark, and it happens every few days.
Right.
To this one employee. That is your typical situation. So, can one thing be enough? If it's bad enough, if it's really bad, then yes.
Okay. All right. Okay. So, Bruce, what type of advice would you give? Would you recommend that they meet and talk about it, or would you recommend someone from the outside coming in and actually doing training, or recommend maybe buying some type of training material?
Well, I'm not sure I'm the best one to give counsel on that, but my first reaction would be that you need to address it in some fashion. If you feel you have capable people on your campus to address it, then get it done. If you don't, get someone in right away. I would think that they could call their insurance company or their attorney. There's all kinds of people that do this for a living. There's all kinds of materials out there. I guess my biggest advice to answer your question would be do something quickly.
Right, and I think that's wise, and I think getting HR and getting your college attorney involved is also a very, very good deal. But as I said before, it's never an easy situation. It's rare, I think, that you sit somebody down and point something out and they say, look, you're right, I crossed the line, I'm sorry. People get defensive. I think it's just natural. It's just human nature, and it's we always say it's much easier to fix a broken step or repair a car that doesn't run well, or to fix a soccer field than it is to try to change human behavior.
Right. It's interesting. My gut says that we shouldn't deal with this on a Christian college campus. We shouldn't have anyone harassing or discriminating another human being. But as we've seen by our first audience poll, most of us have had this situation. So I do think this is really important. Bob, let's go ahead and continue. Let's talk about emerging issues.
Yeah, I mean, this is I guess a slide that I do with some fun, and I kind of like doing it. I like reading the publications. I like reading the stuff that comes out of Washington, and just let's think about what's coming down the road. One thing we do know for sure that the workforce in the United States is becoming much more diversified as time goes on. I think you could just look at the immigration data and just demographic data in general, and it's not a hard thing to predict. What this does is it puts more people in some of the protected classes that Jen talked about. So we would say that there's two things here. There are certainly a lot of opportunities to do things differently, maybe do things better. But there also are challenges because, as I said, there are more people that are now protected under federal or state law, which could lead to more litigation. So I guess it forces us to do things better and be better people. The workforce is certainly aging. I don't think a week or two goes by where you don't pick up an article about how to retain older workers, how to get rid of them, maybe legally when you have to, how to attract newer people, younger people into the workforce. But as Jen mentioned, 40 is still the number for when we get protection under the ADEA, Age Discrimination and Employment Act. So as the workforce ages, there are challenges not only on this side, but also I think I read something a while ago where it said, as the workforce ages, people that have more physical jobs are more likely to be injured, and when they are injured, to be out longer than what they might have been at another time in their life. No one is keeping up with social media. This is changing all the time. Cyberbullying is a term that we all hear about. It doesn't just apply to middle and high school kids. It also applies on the workforce. People can be harassed. They can be discriminated against. They can be told terrible things through email, through posting, through text, as well as they can be in person. So that's a very interesting area, a good idea for another discussion, or a good idea for training at the college level. There are First Amendment issues. People have a right to say certain things there is certainly a need for some type of balancing act between the two. Jen, any comments about First Amendment issues?
And well, normally, non-government employers don't need, to worry so much about that. I think that the trick becomes, when it's okay for an employer to monitor or become interested in what the employee is doing on their own time away from their job. And there have been cases where employees were fired for, say, complaining about their job on Facebook or,
Right.
or what have you. So, I guess it really becomes a question of how much time do you want to invest in monitoring what employees are doing. But also you don't want them out there making a bad name for your institution or, or your company. So it's a bit of a balance.
And what we find, and I'll just speak on behalf of the insurance industry, not speaking on behalf of it, but just an opinion, we're reactive. So, technology creates an exposure. It gets put out usually for a good reason. Then it gets co-opted or it becomes a problem. And it takes the industry a while before they actually respond back, either with risk management recommendations, loss prevention programs, or insurance policies that can actually treat the exposure. But I don't think it's too hard to imagine where and how people get into problems or get into some trouble with that. So Jen, if you have an employee out there, let's say, who is slamming a co-employee who is in a protected class, and there maybe it is a form of harassment, and somebody walks into, let's say, their chair's office and says, listen, I don't know if you know about this, but Jen is getting a lot of really ugly, there's postings about her, there's email being sent about her, there's stuff up on Facebook, and it deals with the fact that she is African American or Hispanic or, the oldest person in the university. So you're sitting there, you're getting that information. It's not on university-provided equipment. It's being done probably after hours.
Well, I think that if the law kind of goes the way it's been going for student claims, then once that issue is brought to your attention and you have reason to believe that it's going to affect the employee's environment at work, then you need to address it in the same way that you address something that happens on your campus.
Okay. Bruce, you have a polling question?
No, I do not, Bob. All of our questions have been asked.
Okay, so I guess as a summary then, kind of like what we talked about last week, is, certainly be honest. When you're in the litigation process, your defense attorney is your advocate, even though they are retained by the insurance company. Their client is the college, the employee at the college, the administrator. It's not the insurance company. Their legal obligation is to you. They will help you prepare. I always say that if your defense attorney tells you to meet him or her in the hallway 10 minutes before the deposition, cancel the deposition and get on the phone with your broker. That's not the way it's supposed to be done. Need to know what's expected during each stage of the process. You folks are the leaders here, so it's not a bad idea to kind of know where things are going. There is no time limit on how many phone calls you want to make to defense counsel, how often you want to meet with them. That cost is borne by the insurance company and not by the college or university. And certainly if you are in trouble or you don't know how to respond to a demand, you don't know what type of records need to be reproduced, if there's an expense involved in getting them, then ask for help, and hopefully whoever your insurer is will be able to provide that assistance.
Okay. Thank you very much, Bob and Jennifer. We very much appreciate your willingness to share your expertise with us. Folks, if you would like to reach out to Bob or Jennifer directly to ask specific questions about your institution, Bob's email address and phone number are there. You can reach Bob or Jennifer through those avenues. And again, thank you very much to Wright Specialty Insurance for sponsoring today's event. Today's workshop has been recorded. If you would like a copy of the recording, simply let me know here at the ABAC office. My contact information is there as well. and we are looking forward to seeing you next week, Wednesday, for Part 3 of Are You Ready for a Liability Claim? Thank you very much, and have a wonderful day.
Thank you.